Welcome to the series of legal maxims. The first maxim is ab initio. It means from the beginning. In the case law Mori Bibi versus Dharmodas Ghosh, the following principle was laid down. A contract or an agreement with a minor is void ab initio, that is, void from the beginning. Let us understand the pronunciation of the maxim. Ab initio. Once again, ab initio. The second maxim is actionable per se. It means the very act is punishable and no proof of damage is required. In the case law Ash B versus White, the defendant had deprived the plaintiff of his legal right to vote in the parliamentary elections. However, the plaintiff did not suffer any damage because the candidate in whose favor the plaintiff wished to vote had won the election. However, the court held the defendant liable because he deprived the plaintiff of his legal right to vote. Thus, in this case, the court referred to the maxim actionable per se. Let us understand the pronunciation once again. Actionable per se. Actionable per se. The third maxim is actio personalis moritur cum persona. It means a personal right of action dies with the person. In other sense, if he dies, the right to sue is gone. Illustration. A hires a popular singer, namely B, for singing at a concert. Accordingly, A sells the tickets of the concert in the name of B. All the tickets were sold owing to B's popularity. Unfortunately, B died few days before the concert and A had to incur a huge loss. In this case, A can neither sue the representatives of B for compensation, nor can he ask the performance of the contract from them, as it is the personal skill of the singer. Therefore, here right to sue will not survive against the representatives of the deceased. That is, right to sue has gone with the person. Now let us understand the pronunciation. Actio personalis moritur cum persona. Once again, actio personalis moritur cum persona. The fourth maxim is acturi incumbit onus probandi. It means the burden of proof is on the plaintiff. In the case law Kedarnath Kohli versus Sardul Singh, the court emphasized on the settled principle of law that it is the duty of the plaintiff to establish the relevant facts which constitute the genesis of his claim by credible evidence. The rule of law is acturi incumbit onus probandi, that is, the burden of proof lies on the plaintiff or the prosecution. The plaintiff's case has to stand on its own legs, and plaintiff cannot claim his claim to be established on account of the weakness of the defendant's case. Now let us understand the pronunciation once again. Acturi incumbit onus probandi. Acturi incumbit onus probandi. See you in the next video with more such maxims. Thank you.